Pam Bondi didn't just stumble today. She collapsed under the weight of courtroom truth that judges say is so shocking it could redefine the entire Trump-era power structure. We're talking evidence walkouts, alleged cover-ups, and a federal judge exposing details so devastating they triggered absolute chaos inside Bondi's camp. Boxes of files, missing timestamps, a paper trail that looks nothing like justice, and everything like a political meltdown spiraling out of control. And now, her entire operation is being exposed in real time. The betrayals, the fallout, the collapse of the story she tried to build. Because the next detail is the one she never wanted you to hear.
Thank you, Chairman Warren and Ranking Member Van Hollen. Thanks for holding this hearing. Welcome, General Bondi.
Thank you, Senator.
Good to see you. I want to raise with you something that's been deeply concerning to me, General Bondi. The 2024 Democrat nominee for Vice President actually called federal immigration agents Donald Trump's modern-day Gestapo. This is dangerous for our agents, it's wrong, and it cuts against and it undercuts the rule of law. So I want to ask you a series of questions, General Bondi, and if you would accommodate me, I would appreciate it. First, you'll agree when a bill is passed by Congress and signed by the President, it's law, right?
Yes, Senator.
And until that law is changed by Congress, you have a duty to follow it, right? That's what the rule of law is.
Yes, Senator.
So let me read the law.
The core of this story isn't Pam Bondi had a bad week. It's the much bigger question. Does the Justice Department belong to the Constitution, or does it get repurposed as a personal weapon for the most powerful person in the room? Because when you strip away the viral packaging, what this transcript is describing is a rule of law emergency. And let me be careful with how I frame this. I'm reacting to what's claimed in the transcript you provided. Judge findings, appointment problems, grand jury issues, evidence handling, and that security footage allegation. Those are serious claims. In a healthy information environment, we'd all be looking at the actual court orders, docket numbers, written opinions, and filings. That's how you tell the difference between a real institutional scandal and a story being inflated for clicks. But here's the thing, even the shape of these claims matters because it maps onto a pattern we've seen again and again in countries that slide toward authoritarianism.
There will never be an enemies list within the Department of Justice.
President-elect Donald Trump's pick for Attorney General Pam Bondi vowed not to use the U.S. Justice Department to target people based on their politics if she's confirmed for the position. But she dodged direct questions about investigating people scorned by the president-elect during her testimony on Wednesday before the Senate Judiciary Committee considering her nomination.
I will not politicize that office. I will not target people simply because of their political affiliation.
The pattern is simple. You take public trust, already fragile, and you grind it down with constant us versus them warfare. You tell your base the courts are corrupt, the media is fake, elections are rigged, and then, once you've convinced people that nothing is real, you start doing things that only work in a world where facts don't matter. You install loyalists. You dodge oversight. You treat rules like speed bumps. You apply law and order to your enemies. And, oopsie, to your friends. That's the through line here. Rule of law versus rule by loyalty. And if the allegations described in this transcript are accurate, this is what rule by loyalty looks like when it runs face first into a federal courtroom. Start with the rule of law exchange. It's almost comically basic. If Congress passes a law and the president signs it, it's law. Until it's changed, it has to be followed. That's not partisan, that's civics. But what makes it important is that it establishes a standard on the record. You don't get to pick which laws count. You don't get to treat statutes like optional settings based on the day's politics. Now, here's where the hypocrisy starts to creep in. Authoritarian politics loves to cosplay as law and order, but it's not actually attached to law. It's attached to order, specifically order that benefits the leader and punishes dissent. That's why you'll see a movement demand harsh consequences for protesters, journalists, whistleblowers, or enemies, while simultaneously demanding immunity excuses, and endless second chances for people in the in-group. So when this transcript describes prosecutions that supposedly targeted Trump's political critics, high-profile names like James Comey and Letitia James, you're immediately in the danger zone. Not because those people are saints, they're not. It's because when a Justice Department is perceived as selectively hunting political enemies, you don't just damage a case. You damage the legitimacy of the institution that's supposed to be the referee. And this transcript insists it wasn't merely perception. It claims judges didn't just dismiss cases, they eviscerated the prosecutorial structure. It claims there were foundational legal defects. And if that's true, that's a big deal, because the guardrails are not optional. They're not decorative. They exist precisely to prevent presidents from turning prosecutions into a form of political punishment. One of the biggest claims here is about an interim U.S. attorney appointment, Lindsay Halligan, described as unlawfully appointed. I want you to understand why that's not some paperwork nitpick. The appointment rules are basically a firewall. They're one of the ways the system tries to prevent a president from saying, I want that person indicted, so I'm going to install a loyalist who will do it. When you bypass the legal requirements for who can exercise prosecutorial power, you're not just committing a procedural error. You're making a statement, I don't recognize limits. And in a democracy, limits are the whole point. If the person signing indictments didn't have the legal authority to do so, then the prosecution isn't just weak, it's illegitimate. Imagine if a random person walked into a courthouse, put on a suit, and signed charging documents. The ink doesn't magically become valid because the suit looks official. Authority matters. Legal authority is the difference between the state enforcing law and someone performing state power as theater. That's why judges use sharp language in cases like this. Because judges are not just ruling on one headline. They're defending the idea that the government must follow its own rules. If the accusation is the state is abusing its power, one of the first things a court looks at is, did you even have the power you claim to be using? Then you get into the grand jury allegations. And this is where it stops being politics and becomes, this is how we protect people from government overreach. In the American system, a grand jury is supposed to be a check. Imperfect, yes, but still a check on prosecutors. It's one of the few points where ordinary citizens are supposed to act as a gatekeeper before the state drags someone into court with criminal charges. So when this transcript claims a judge found fundamental misstatements of the law presented to a grand jury, that's not normal. That's not aggressive prosecution. If prosecutors misstate the law to obtain charges, they're not presenting a case, they're steering a result. And that's exactly the kind of behavior that turns a grand jury process into a rubber stamp. The transcript also claims there was potentially privileged material used improperly. Again, privilege isn't a loophole for rich people. It's part of how we protect the integrity of legal counsel and confidential communications. When privilege is violated, the consequences aren't just about fairness to the target. It's about preventing the state from turning private legal communications into ammunition. And then there's the chaotic indictment process. Allegation. So chaotic that the judge questioned whether the grand jury even saw the final charging documents. If that's true, it's not a small glitch. The entire concept of grand jury approval is that the actual charges filed are the ones reviewed and approved. If the process gets scrambled in a way that breaks that chain, you're not just messing up a step. You're undermining the safeguard. This is where I want to say something to viewers who might be tempted to shrug this off because they don't like the people being targeted. Don't do that. In democracies, the only meaningful test of your principles is whether you apply them to people you dislike. If you only care about due process for your side, you don't care about due process. You care about winning. And that's how a country becomes a place where the law is just a costume people wear to punish enemies. This transcript is basically arguing that the cases weren't dismissed because judges sympathize with Comey or Letitia James, but because the prosecution itself was built wrong. Like someone skipping structural supports in a building and then acting surprised when it collapses. Now, the most explosive allegation is the one about security footage and missing files. Bondi allegedly leaving with boxes after an evidence preservation order, with timestamps lining up with documents that later couldn't be located. Let's slow down because this is serious. When a judge orders evidence preservation, that isn't just a suggestion to be careful. It's a legal command that recognizes a basic truth. People have incentives to hide, destroy, or manipulate evidence when the stakes are high, especially powerful people, especially when politics is involved. That's why courts treat chain of custody like sacred ground. If evidence handling is compromised, you can't trust the proceeding. So the allegation here isn't she carried boxes. It's the implied sequence: preservation order, removal of materials, missing files. If that's accurate, it resembles the shape of obstruction. That's why in ordinary cases, prosecutors treat evidence tampering like a cornerstone offense. It's not just wrongdoing. It's wrongdoing that attacks the justice system itself. And that's the irony the transcript keeps hammering. If anyone else did this, they'd be staring down severe consequences. Meanwhile, the Attorney General, who's supposed to enforce the laws against obstruction, would be accused of living above the rules. That creates an institutional crisis because the DOJ's authority is not just about guns and badges. It's about credibility. Prosecutors ask judges to trust them. They ask juries to believe them. They demand that witnesses comply, that defendants follow orders, that the public accept outcomes even when they're unpopular. If DOJ leadership is seen as playing games with evidence, that credibility evaporates. Defense attorneys will exploit it in every case. Judges will become more skeptical. Juries will be more suspicious. And that damage spreads to cases completely unrelated to politics: fraud, trafficking, public corruption, violent crime. Everything gets harder when the public thinks the referee is cheating. Now, the transcript frames this as a revenge prosecution strategy that backfired. And here's the broader political danger. Even a prosecution that collapses can still achieve a political goal. Because in authoritarian-leaning movements, the prosecution itself is the punishment. You don't need a conviction to ruin someone's life. You just need an investigation, a headline, a mugshot-style media cycle, and months of legal bills. You create a chilling effect. People start thinking, if I cross the leader, will I be next? That's how intimidation works inside legal systems without openly abolishing courts. And that's why, again, procedural integrity matters so much. If the state can bring cases without proper authority, then law becomes a weapon you can aim at anyone. This transcript also mentions Bondi being front and center on other politically explosive issues: Epstein files, SNAP benefits litigation, immigration enforcement. Whether or not those specific references are accurate, the underlying point is valid. When top DOJ leadership loses credibility, it contaminates everything they touch. Think about the Epstein files example. That's an issue where trust is already brittle. People suspect cover-ups. People suspect political protection. People suspect selective disclosure. If the same person is seen as untrustworthy, then even true disclosures will be doubted, and false claims will spread faster. You get a perfect storm of conspiracies and institutional weakness. That's the tragedy of corruption and misconduct. It doesn't just hurt one case. It creates a vacuum that misinformation fills. Now, I want to address something else embedded in this transcript because it's a rhetorical trick that shows up constantly in NAGA media ecosystems. The trick is to claim mainstream media can't be trusted, and then to offer an alternative source that also wants you to stop checking original documents. They'll say, don't believe corporate media, believe us. But the principled alternative isn't swapping one narrator for another. The principled alternative is Show the receipts. So if this story is real, it should have receipts, the written judicial opinions, the docket entries, the dates, the language and context. And if it doesn't, then everyone should step back and treat the most explosive claims as unverified until they're confirmed. That's not me doing both sides. That's me protecting you from being manipulated, whether by corporate media, partisan media, or viral content machines that benefit when you're angry and glued to a screen. But here's what I will say confidently. The framework of the story is plausible because it matches how institutional abuse happens. You see leaders push boundaries, then test courts, then attack judges who push back. You see loyalty rewarded. You see oversight dismissed as witch hunts. You see the public pressured to choose a team rather than demand standards. And it's the standards that keep us free. So what happens next? If these allegations are backed by real court findings, the consequences could cascade. First, the legal consequences. If appointments were defective, other cases signed by the same authority could be challenged. If grand jury processes were tainted, defense attorneys will file motions. If evidence handling was compromised, courts may impose sanctions, dismiss charges, or refer conduct for investigation. The ripple effects could be massive. Second, the political consequences. Law and order branding collapses when it's paired with misconduct. That creates an opening for demagogues to respond in one of two ways. Either they change behavior, or they double down and try to break the system that exposed them. Historically, the second option is the one authoritarian-aligned movements choose. They don't say, "We messed up." They say, "The judge is corrupt." They try to delegitimize the institution that stopped them. Third, the civic consequences. When people lose faith in justice, they become vulnerable to cynicism. They start thinking everything is rigged, so nothing matters. That's the death of democracy, because democracy requires participation, the belief that rules matter and outcomes can be legitimate even when you don't get your way. That's why, to me, the single most important line in this entire discussion is not a catchy insult. It's not a viral claim. It's the simple standard. The law is the law. Prosecutors must follow it, and the Justice Department must be bigger than one man's grudges. If Trump and his movement want a country where the DOJ is a revenge tool, then we should say it plainly. That's a country sliding away from constitutional democracy. And if they claim to love the Constitution, then this is the test. Not slogans, not flags, not patriot branding. The test is whether you accept limits on your power, especially when you're angry. Because the idea of America is not that our leaders are saints. It's that our leaders are constrained. It's that we don't worship any one person above the rules. It's that courts can say no, and that no holds. So my closing thought is this. If you care about freedom, if you care about democracy, then you have to care about the boring guardrails, appointments, procedure, evidence preservation, truthful representations to courts, because those are the mechanics that keep power from turning into tyranny. And if the allegations in this transcript are true, then a federal courtroom just did what it was designed to do, force power to answer to law. That's not partisan, that's patriotic.